5 seconds to go. Start. Furthermore, there is a birth certificate issued by the Gram Panchayat Bhind, Madhya Pradesh, which indicates the date of birth of the petitioner as 5th January 1982 and note 1st January 1982 as recorded in the school certificate referred to above. The entry in the records of the Gram Panchayat Bhind, Madhya Pradesh also do not appear to be contemporaneous, and the certificate has been issued in the year 2017. However, as pointed out by learned counsel appearing on behalf of the petitioner, that the Sessions Court has recorded the age of the petitioner as 16 years, 9 months, and 19 days. The petitioner has been in actual custody for over 3 years. The 2000 Act has been repealed and replaced by the Juvenile Justice, Care and Protection of Children Act 2015. Section 21 of the 2015 Act provides that order that may not be passed against a child is conflict with law. No child in conflict with law shall be sentenced to death or for life imprisonment without the possibility of release for any such offence, either under the provisions of this Act or under the provisions of the Indian Penal Code or any other law for the time being in force. Considering that the trial court has recorded the age of the petitioner as 16 years and old and has been in actual custody in excess of 3 years, which is the maximum for a juvenile, we deem it appropriate to grant the petitioner interim bail on such terms and conditions as may be imposed by the Sessions Court. We further direct the Sessions Court to examine the claim of the petitioner to juvenility in accordance with law and submit a report to this court within 1 month from the date of communication of this order. The concerned Sessions Court shall be entitled to examine the authenticity and genuineness of the documents sought to be relied upon by the petitioner, considering that the documents do not appear to be contemporaneous. In the event the documents are found to be questionable, it will be open to the Sessions Court to have the petitioner medically examined by taking an ossification test or any other modern recognized method of age determination. The aforesaid order passed by the coordinate bench has been relied upon by the learned counsel appearing for the state to fortify his submission to their petition in the court. In regard to the juvenility of the writ applicant requires consideration. The same should be by the Sessions Court, that is the court which had originally tried the writ applicant for the alleged offence. In such circumstances referred to above, the learned counsel appearing for the state prays that let the Sessions Court look into the certificate issued by the medical board, including the family register, more particularly its authenticity and genuineness. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only question that falls for our consideration is that whether we should ask the Sessions Court to examine the authenticity and genuineness of the documents sought to be relied upon of being a juvenile on the date of the commission of the alleged offence in the year 1982 and also subject the convict to further ossification test. The first and the foremost issue that arises for our consideration in this writ petition is in regard to the applicability of the provisions of the Juvenile Justice, Care and Protection of Children Act 2000. In the aforesaid context, we must first look into the relevant dates as 1. The date of the incident is 10th September 1982. Thus, on the date of incident, even the Juvenile Justice Act 1986 was not in force. What was in force was the Children Act 1960. The Children Act 1960 was a beneficial legislation enacted to take care of the delinquent and neglected children. Under the said act, a child meant a person who had not attained the age of 16 years in the case of a boy or 18 years in the case of a girl. 2. The petitioner herein came to be convicted by the trial court, wide judgment and order dated 6th January 1986. Even on the date of conviction, the Juvenile Justice Act 1986 was not in force. The Juvenile Justice Act 1986 came in force with effect from 1st December 1986. Thus, even on the date of conviction, the Children Act 1960 governed the field. 3. The appeal filed by the petitioner herein in the High Court of Allahabad against the judgment and order of conviction passed by the trial court came to be decided and was ordered to be dismissed, wide judgment and order. It is relevant to note that on the date when the appeal came to be dismissed by the High Court, the 2000 Act was in force, and 4. Special leave to appeal filed by the petitioner herein in this court came to be dismissed wide order dated 16th August 2016 as per the decision of the juvenile court. Stop.